Morning.
Officer Dade, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone.
Good morning.
Your Honor.
Good morning.
Morning.
Mr. Barta, and we'll get started. Good morning. All right, let's see who we have here today. Mr. Capone, I think you were here first. What case do you have?
I'm here for the open MRI, George Henderson versus Nationwide Matter.
Was that 713 or 322?
322, Your Honor.
22. Ms. Beverly, you here on that one?
I am.
Okay, so I have a pair there. And Mr. Braxton, you're here for what?
I'm here on the open MRI Allstate, the 713 matter
Okay,
for defendant.
Braxton. Ms. Beverly, you're here on that one as well?
I am.
Okay. And Mr. Barta.
I am here, Your Honor, on Calvary versus Gloria Thomas set at 10 o'clock pretrial.
All right. Okay, so I don't have your pair yet, but I have the pairs for the other two. And before I get started, let me read the public satisfaction survey announcement. Before we begin today's hearing, I would like to talk about the public satisfaction survey. This survey allows court users to rate the court's accessibility and its treatment of the public in terms of fairness, equality, and respect. This survey will also help us better understand how we are providing service remotely. By providing us with feedback, we can make good public service even better. This survey is for everyone involved in a hearing today and will not affect your case in any way. It is completely optional and will take about 3 minutes to complete. A link has been placed in the Zoom chat, which will allow you to take the survey online. To access your Zoom chat, click on the very bottom middle of your Zoom screen where it says chat. Once you open that chat, click on the link that I provided and a browser window will open with the survey. In the event that the chat is closed or unavailable, the link will also be placed on the court's website, which is www.36districtcourt.org under the announcement section. All right. Let's begin with open MRI of Livonia versus Titan Insurance, which is 322. So Mr. Barta, off to the waiting room. Mr. Braxton, off to the waiting room. Okay, we are on the record calling case number 20160-322. Open MRI of Livonia versus Titan Insurance. This is our first pretrial. Your respective appearances.
Good morning, Your Honor. Harold and Beverly on behalf of the plaintiff, P44028.
Good morning, Your Honor. Kevin Capone appearing on behalf of the defendant, P number 82518.
All right, this is apparently our first pretrial. So my first question is whether or not you guys have made the 302 disclosures.
Not that I'm aware of, but I fully anticipate doing so.
Mr. Capone?
Your Honor, not to my knowledge as well. We can get those out as soon later today or later this week. Absolutely.
Notice that brings you here today. Said y'all were supposed to make those within 21 days of January 26th. And I know you got to notice because you're here. Let's get you another date. Let's move forward. Does April 6th work for both of you?
It does.
Yes,
Thank
Your
you,
Honor.
Your Honor.
All right, April 6th at 10 o'clock. We'll try this again. Now, I should tell you, the next time we are together, if those disclosures are not made, I will default or I will dismiss the case.
Understood, Your Honor.
Understood.
Okay. That
Thank you.
concludes our hearing, but before you leave, I have something else to read. Is this ridiculous or what? Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. This survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to, and you may end the survey at any time by clicking to the end of the survey and hitting the done button. This feedback is very important to us to help us better serve the public. We greatly appreciate your time. End of statement. So thank you both for coming in April 6th, and let's get those disclosures done.
Will
Thank
do,
you.
Your Honor. Thank you. Have a good day.
Have the same.
I'll stay on.
Stay on, right?
Are you the only judge that they're asking to make those statements?
No, actually, we got this from Supremes.
Oh,
I don't know how long I'm going to continue with this. It's ridiculous, right? We do the public satisfaction survey every year. I don't know how well it works online, quite frankly. Okay. Let's try your next case, which is 713. That's Mr. Brackett. All right, we are on the record calling case number 20156-713. The file is entitled Open MRI of Livonia versus Allstate Insurance. This is a motion to set aside default filed on behalf of the defendant, your respective appearances.
good morning, Your Honor. Harold and Beverly on behalf of the plaintiff, P44028.
Eric Bracken on behalf of the defendant Allstate, P61690.
Failed to answer. Why should I set it aside?
Well, Your Honor, I believe that we've established what we need to under the court rules, that there's a meritorious defense in this case, as outlined, that the charges are not reasonable. The actions were not necessary. There's an issue with whether or not the injuries are even causally related to the motor vehicle accident issue. We are defending other cases for the same person, same accident, just other providers. There was certainly no intentional attempt. This occurred back in June, July of 2020. It was just fell through the cracks, unfortunately, at Allstate. The complaint was logged but never assigned. We believe that there's no prejudice. We've already produced a claim file, and are certainly open to quick resolution and or negotiations with regards to this. It should also be noted, and I think we pointed out, that the plaintiff was able to take advantage of the 1 year back rule grace period for COVID under the statute of limitations. Had they filed when they actually filed, they would have missed the 1 year. So they were able to take advantage of some COVID relief. We don't know the exact reason. I'm sorry.
Wasn't that COVID relief available to everybody?
It was. That's correct. We don't know why, and Allstate has not been able to determine. I'm sorry.
I don't understand why that's relevant if you agree that the COVID relief was available to all. I don't understand here on either good cause or meritorious defense. And while you're talking, I'd be happy to hear what you say about the line of cases that says ordinary negligence does not constitute good cause. Please continue.
Okay. Well, Your Honor, we believe that we've also attached the affidavit of the adjuster who states that there is a meritorious defense, and
that's all. I'm sorry, help me out. I'm wrong. I'm slow. My understanding is in order to set aside default, you must demonstrate both good cause and meritorious defense. And what you're doing is giving me a listing of what you believe to be meritorious defenses. Assuming that to be true, assuming those things to be true, how do I deal with the line of cases that says negligence is not good cause? since you must establish both good cause and meritorious defense.
Well, we don't feel as if this rose to the level of negligence. We believe this was certain. I'm sorry?
What would you call it? You acknowledge receipt, you acknowledge logging in the complaint, and then a winner set on the desk. What would you call it?
I believe I would call that an oversight.
And you would distinguish that from negligence, how?
I would distinguish that negligence is that negligence, there has to be,
Failure to act reasonably under the circumstances.
yeah, and I,
Not answer a complaint and stick it on the desk, is it not? That's
I-
they have time driven responsibilities.
I believe that during this time and in this day and age, what happened was it wasn't a physical piece of paper that sat on a desk. Because everything is logged electronically, it was simply an oversight and not logged properly. It was a computer error that someone failed to properly log and or do their job. But I do not feel as if it rose to the level of negligence in any way. I do believe that it's simply an oversight. It was a clerical mistake, certainly not intentional. And it does not rise to that level, and that out of equity, we believe that this default should be set aside.
Let me hear from Ms. Beverly.
Your Honor, I have a couple things to say. Number one, in defense counsel's brief, they make an issue of this COVID relief. And they try to say that because the Michigan Supreme Court in their administrative order 2020-18 told everything, that they then get to answer the complaint whenever they want. That's not the case, number one. There is no administrative order that speaks to a defendant having additional time to answer a complaint that is properly served and properly filed, one. Two, in their pleadings, I don't see any discussion of the clerical error that existed, just that one happened. And I think the court is right in the discussion of ordinary negligence in this case. And three, I don't recall getting a claim file on this case, but most importantly, Your Honor, I'd ask that all the pleadings that they filed subsequent to the issuance of the default be stricken, because the court rule is clear. Once a default is entered, nothing is to be done until the default is lifted. And in this case, not only did they not answer when they were supposed to answer, once the default was entered, they then went ahead and filed a whole bunch of other pleadings without the default being set aside. And then finally, the court rule says and dictates that if the default is set aside, costs are to be levied or assessed, whatever word, the honor, you'd like to use. And in this kind of case before, I understand that we're in COVID, but I did appear before, and my hourly rate that I'm typically given on these is somewhere around $3.50. I don't understand how, and this is becoming a new thing. People get answers and people don't want to answer them. And then they come to court and say there was a clerical error, but their paperwork doesn't, and their filing doesn't really show that there was a clerical error. And I don't know. That's what I have to say.
Your response, sir.
Well, Your Honor, I guess I would love to be able to outline exactly how the clerical error occurred. Unfortunately, because it was a lack of action, it's impossible for me to kind of proactively show it with any proof or written statement. I do believe that this was a clerical error. Certainly, I'm open to, the rest of the relief that she said. I understand if the court orders that, whether it be striking the pleadings filed after, where, if the court were to set this aside, we could certainly refile everything. We would stipulate to that, and certainly understand the issue of costs in this matter.
All right, I'm prepared to rule in the matter. The court is going to grant the motion to set aside the default in this matter. I think this is sloppy lawyering. You have chosen to have an electronic system to operate your business, and that's fine and dandy. The system has to operate. The court will order that you pay attorney fees in the amount of $250 within 10 days of today. All pleadings that you have filed subsequent to the entry of the default are hereby ordered stricken, and you will present an order, sir, to that effect under the 7-day rule. Both of you will make the MCR 2.302A disclosures within 21 days of today. We'll have you back on April the 6th. Does that work for everybody?
Yes.
Yes, Your Honor.
April 6th at 10 o'clock. You're going to get 2 orders. You're going to get an order scheduling the pretrial for April 6th, 2021 at 10 o'clock, requiring that the disclosures. Now, when I talk about making the disclosures, you don't need to send them to the court, but you do need to send me proof of service that you did provide them to the other side. I don't need them for my file. And that $250 within 10 days of today, the disclosures within 21 days of today, so that when we're together again in April, the attorney fee issue would have been resolved, the disclosures would have been made, and we'll be in a position to talk about moving forward on the file. Is there anything else?
Just one point. Brother counsel, are you the lawyer that will be on this case from this day on?
I'll be assisting Matt, so that, yeah, both of us, but I can email you. I have it right here up in front of me
Thank you.
for the specifics.
Before I release you, I have another statement to make concerning the public satisfaction survey. Now that we have ended today's hearings, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. This survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to, and you may end the survey at any time by clicking to the end of the survey and hitting the done button. This feedback is very important to us. Help us better serve the public. We greatly appreciate your time. So by the time I see you next, 7-day order to strike all pleadings filed after the entry of the default. The attorney fee of $250 paid. Both sides have made the 2.302A disclosures and filed proof of service with the court. Anything else, folks?
No, thank you.
No, thank you, Your Honor.
The other question. There are, I take it, Mr. Brackett, ongoing litigations involving this same injured party?
Correct.
Are those litigations in the circuit court?
Some are in circuit and some are dispersed amongst other district
Oh, okay.
courts.
Because I was thinking it might be useful in terms of efficiency of time for you folks to try to get all of your cases concerning the PIP issue here of one judge. You know, maybe you could all decide to intervene in the circuit court case. If not, it's up to you. Okay,
Thank you, Your Honor.
Thank you.
thank you both for coming in. We are off the record. Please.
Thank you.
Thanks for coming in.
Bye-bye.
Okay, let's stop the video. Okay. All right, we are on the record calling file number 20154-984, Calvary SPV1 LLC versus Gloria Thomas. This matter is set for pretrial today, March 2nd at 10 o'clock by a notice dated January 25, 2021. It's currently 10:31. Your appearance.
Good morning, Your Honor. Suzanne Barta, P65425 on behalf of the plaintiff.
All right, Mr. Barter, the defendant here has failed to appear. What is your pleasure, sir?
Your Honor, at this time, we're requesting a default judgment.
All right, I have a proposed default judgment that was sent over by your office. That's the one you want to use?
Yes, Your Honor, if you could. Sorry, Your Honor, I'm just going to pull this up real quickly. What are the amounts on that, Your Honor?
Damages were $9,093.39. Costs of $132.75. Total $9,226.14.
That is correct, Your Honor.
Okay, then I'll go ahead. I'll just enter that default judgment, entering the default of the defendant for failing to appear. No good cause that failure having been shown.
Thank you very much, Your Honor.
Off the record.
Have a good day.
You too, sir. All right, what's next is for me. Put this one. Okay. All right. Ms. Nelson,
Good morning.
good morning. What file do you have?
Affiliated Diagnostics versus the city. Last three are 639.
Ms. Dolan, is that why you're here?
Yes, Your Honor. Is this Ronald Cross?
Yeah.
Okay.
Okay, well then let me put the other party in the waiting room and we can do you guys now.
Okay.
Okay. We are on the record calling file number 20156-639, Affiliated Diagnostic versus City of Detroit. Your respective appearances.
Good morning, Your Honor. Tricia Nelson, P68707, appearing on behalf of the plaintiff.
Morning, Your Honor. Sarah Doman, P79128, on behalf of the defendant.
Okay, before we get started, I have to read this public satisfaction survey announcement. Before we begin today's hearing, I would like to talk about the public satisfaction survey. This survey allows court users to rate the court's accessibility and its treatment of the public in terms of fairness, equality, and respect. This survey will also help us better understand how we are providing service remotely. By providing us with feedback, we can make good public service even better. The survey is for everyone involved in the hearing today and will not affect your case in any way. It is completely optional, anonymous, and will take about 3 minutes to complete. A link has been placed in the Zoom chat, which will allow you to take the survey online. To access your Zoom chat, click on the very bottom middle of your Zoom screen where it says chat. Once you open that chat, click on the link I provided and a browser window will open with the survey. In the event that the chat is closed or unavailable, the link will also be placed on the court's website, which is www.36districtcourt.org under the announcement section. Okay, let us proceed with our case. We are on the record with file number 20156-639, Affiliated Diagnostic of Oakland versus City of Detroit. Our discovery is closed here, folks. Where are we on this file?
Yes, Your Honor. Discovery is closed. I think we may have had some discussion around the last hearing. And if the court is inclined to give us a date, defendant has a motion that it would like to file.
A dispositive motion?
Yes, Your Honor.
How long will it take you to file it?
A week or two.
You get a week, I'll set it out for 30 days. And that'll
Okay.
give everybody time to have the hearing date. You're gonna have to file a motion for summary disposition? Is that what
Yes.
you're telling me, Ms. Doman?
Yes, Your Honor.
April 6th at 11 o'clock. Does that work for both of you?
Your Honor, that date does not work for me for a hearing.
What about April 7th?
The morning works for me on April 7th.
What about you, Ms. Nelson?
You said at 11 o'clock?
Yes.
That should be fine, Your Honor.
April 7th at 11 o'clock. We will calendar defendant's motion for summary disposition. All right, is there anything else we should accomplish today?
Not from plaintiff, Your Honor. Thank you.
Just to be clear, Your Honor, the motion will be due a week from today.
Yeah, because she's entitled to 3 weeks.
Yes, so March 9th.
Yeah.
Okay, just making sure.
All
Okay.
right. Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. This survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to, and you may end the survey at any time by clicking to the end of the survey and hitting the done button. This feedback is very important to us to help us better serve the public. We greatly appreciate your time. Thank you for coming in.
Thank you, Your Honor.
Thank you.
Good morning.
Good morning, Your Honor.
Who do I have
Good
at
morning, Your Honor.
telephone 9,000?
This is Attorney Thomas Duquette for Nottingham Place.
And who do I have at 2794?
Your Honor, this is Jalen Davis.
All right, let us begin. We are on the record calling file number 191827993. The file is entitled Nottingham Place 18 Capitol, which is Jalen Davis. Your respective appearances.
Good morning, Your Honor. Thomas Duquette, P82958 on behalf of the plaintiff.
And your name, ma'am?
Your Honor, my name is Jalen Davis.
All right. Before we begin, let me read a statement concerning public satisfaction survey. Before we begin today's hearing, I would like to talk about the public satisfaction survey. This survey allows court users to rate the court's accessibility and its treatment of the public in terms of fairness, equality, and respect. This survey will also help us better understand how we are providing service remotely. By providing us with feedback on this anonymous survey, we can make our good public service even better. The survey is for everyone involved in the hearing today and will not affect the case in any way. It is completely optional and anonymous and will take about 3 minutes to complete. A link has been placed in the Zoom chat, which will allow you to take the survey online. To access your Zoom chat, click on the very bottom middle of your Zoom screen where it says chat. Once you open the chat, click on the link I provided and a browser window will open with that survey. In the event that the chat is closed or unavailable, that link will also be placed on the court's website, which is www.36districtcourt.org under the announcements section. Now, let us begin. We are here scheduling today. This is the adjourn date for a motion for summary disposition filed on behalf of plaintiff in this matter. The motion for summary disposition was initially set for hearing on November 30th and adjourned to this date because the defendant had surgery. Your appearances have been made. Now, I have a question. Ms. Davis, did you file an answer to this motion for summary disposition?
Your Honor, I did not receive a motion.
Well, wait a minute, ma'am. I have a letter from you asking for a continuance of the first date. So how did you not receive it?
Oh, Your Honor, I'm sorry. Yes.
All right.
Yes, I did. I'm sorry.
Did you file an answer to it, ma'am?
Yes. No, I did not. I'm
Oh, you
sorry.
did not. Thank you. Mr. Duquette,
Yes.
your motion.
Thank you, Your Honor. This plaintiff's motion brought under MCR 2.116 C9 and C10. The underlying debt here is the damages that are associated with defendant's breach of a lease agreement that she signed to rent an apartment within plaintiff's apartment community. Defendant breached the lease agreement by maintaining possession of the apartment after the expiration of the lease date. The lease was initially entered into for a term of 1 year. From May 4th of 2016 to May 5th of 2017. Because of defendant's breach of the lease by holding over, plaintiff was forced to treat defendant as a holdover tenant and was forced to seek and subsequently obtain an order of eviction from the 8C District Court. It's attached to plaintiff's motion as Exhibit B. Under MCR 2.116 C9, defendant has failed to raise a tenable legal defense here, which results in her not being able to deny plaintiff's right to recovery. Defendant failed to properly relinquish the premises prior to the expiration of the agreed upon lease termination date. That was due to the fact that she never turned in keys to both the premises and its common areas, never provided plaintiff with a forwarding address for a statement of damages to be sent to, and never paid plaintiff the outstanding rent owed under the lease agreement. As a result, plaintiff was forced to treat defendant as a holdover tenant, had to seek and subsequently obtain an order of eviction, which was eventually entered on June 21st of 2017. It had the effect of terminating defendant's holdover tenancy by operation of law. Accordingly, plaintiff should be entitled to judgment under MCR 2.116C9 as defendant has failed to raise a tenable legal defense. Furthermore, pursuant to MCR 2.116C10, there is no genuine issue of material fact here. Defendant did sign a lease agreement. She doesn't dispute that fact at all. She breached the lease agreement, as I previously stated, by failing to terminate her tenancy properly prior to the agreed upon lease termination dates. And due to that breach of the lease agreement, she is liable to plaintiff for the damages that resulted. Furthermore, the defendant failed to respond to plaintiff's discovery request. Those were served upon her August 21st of 2020. And on top of that, defendant has failed to respond to plaintiff's motion for summary disposition, despite the fact that it was sent to defendant twice. Once prior to the pretrial hearing on October 22nd, and then again after the pretrial hearing on October 22nd when defendant requested it be sent to a different address. Based on all of this, the fact that there's no genuine legal defense under MCR 2.116C9, the fact that there's no genuine issue of material fact under MCR 2.116C10, the fact that defendant has failed to respond to plaintiff's discovery request, which means that each of the requests for admissions are deemed admitted pursuant to MCR 2.312B1, and the fact that defendant has failed to respond to plaintiff's motion for summary disposition, plaintiff should be entitled to judgment as a matter of law.
Thank you. Ms. Davis, is there anything you didn't file an answer? Is there anything you want to tell the court at this time?
Your Honor, I know he said after August, the last thing I received from them was in August, but I have not received anything else from them besides that date. My mother said that they're still sending mail to her residence, but I have not received anything. And also, Your Honor, I met with the complex before I moved out. I wrote out the letter that you have, I'm pretty sure that you have in front of you. I handed that as well, along with my keys, to their front desk receptionist, Amanda, and had a conversation with her. She told me that they do not do walkthroughs and that I would be able to get my deposit back within 2 weeks. And I provided them my forwarding address, a copy of my new lease that had that address on it, my cell phone number, as well as my email address. And I never received anything until about 2 years when the complex that I was looking to move into, they told me that there was a credit on my account from Nottingham. I tried to contact them numerous times, as well as 18 Capital Group, without a response to anything.
All right. Court is
saying that I owe this debt.
All right. The court is prepared to rule in this matter. This is a motion for summary disposition filed on behalf of plaintiff under MCR 2.116C9 and C10. The court is going to make its ruling under MCR 2.116C10 to claim that there is no genuine issue of material fact here, for the reason that matters are being considered here outside of strictly the pleadings. The most significant thing here is that the defendant acknowledges she has not filed an answer to the motion for summary disposition. Further, she said that she did not get anything from the plaintiff after August of 2020. That was when the request for admissions was served. Those requests for admissions under MCR 2.312B1 must be deemed admitted because not answered in a timely fashion. The requests for admissions include, and I'm not reading all of them, just in pertinent part, defendant admitted that the defendant occupied the lease premises, admitted in paragraph in regard to number 3, she failed to turn in the keys, and admitted in number 5, in number 7, that, paragraph 8, that the plaintiff's damages are actually accurately stated in the final account statement. The requests for admissions, having failed to be answered, are deemed conclusive for the purpose of this litigation. I further note under MCR 2.116G4, the court rule is quite specific concerning a motion for summary disposition under C10. A motion under subrule C10 must specifically identify the issues as to which the moving party believes there is no genuine issue as to any material fact. When a motion under subrule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleas, but must, by affidavit or otherwise provided in this rule, set forth specific facts showing that there's a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. Based upon the pleadings in this matter, the failure of the defendant to respond to the motion for summary disposition, the failure of the defendant to respond to the request for admission, court finds under MCR 2.116 there is no genuine issue of material fact. Plaintiff's motion for summary disposition, MCR 2.116C10, is therefore granted. Mr. Duquette, you will submit your proposed judgment, under the 7-day rule. Ms. Davis, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. That concludes the hearing for today. Before either of you leave, let me read one more thing concerning the public survey satisfaction survey. Now that we have ended today's hearing, I would like to remind everyone to please complete the public satisfaction survey via the survey link I have provided in the Zoom chat. The survey is completely optional and anonymous. It will take about 3 minutes to complete. You do not need to answer any questions you do not want to. You may end the survey at any time by clicking to the end of the survey and hitting the done button. The feedback is very important to us to help us better serve the public. We greatly appreciate your time. Thank you both for coming in. We are now off the record.
Thank you, Your Honor. Have a good day.
Ma'am?
Thank you, Your Honor.